Hey guys, it's Gary, and I got a pretty interesting topic today. It's about terminating the contract prior to the date that the earnest money is due and what happens. So, Mark, a broker up in the Upstate's a good friend of mine, asked me this question. I thought it was a good question that I should share with all of y'all, and particularly since we have the new contract and the CCRA contract, both have a due diligence period. In the past, we've advised because of the way earnest money is not being held by agents, that earnest money is now being delivered to an attorney, that you need to make sure that if you're not holding the earnest money physically in your hand, that's denoted in the contract. And one of the issues you might see in the contract is when somebody would say, here's the offer we're making $1,000 herewith, making it appear that the earnest money is in the agent's hand when in fact the agent doesn't have the earnest money, that we're saying to put zero earnest money and then put $1,000 or whatever the earnest money is to be paid at a certain date, whether it's 5 days after ratification or at the completion of the due diligence period. And so the question Mark brought was, what happens if we have a contract like that where it says $1,000 earnest money shall be paid upon the completion of the due diligence, but the parties terminate the contract properly and legally during the due diligence? Does the agent, for their record keeping, still need to go collect the earnest money and then refund it? And the answer to that would be no, because they never got to the completion of the due diligence, because that was the trigger date for paying the earnest money, was the completion of the due diligence. But during the due diligence, they terminated the contract. So there would be no reason to collect the money, do the termination, and then refund the money. So what I would recommend you do is in the termination agreement, whether you're using the state contract or using the CCRA contract termination form, is that you put in there the contract's hereby terminated, and then make a note that the earnest money was not due and payable until completion of due diligence or whatever date it is, and the parties terminated before the due date. Therefore, no earnest money was paid in this, and the contract is hereby just terminated. So it would make your records complete. It would go along with the contract. If you ever get audited or anything was ever brought up, you could be able to show LLR, the Realtor Association, the contract didn't call for the earnest money until this date. We never got to that date. I denoted that properly in the termination agreement. The parties signed the termination agreements agreeing that the earnest money was not due at that point. And I think that would be perfectly fine. That would be how I would handle it. And I think that it makes the most sense. So that would be the answer to your question. If you have any questions about that, don't forget to reach out to us. And by the way, I love when y'all send me these emails. It does give us great topics to include for other agents to learn from as well. So if you do have a question like this, just email me at gary@blaircato.com, and we might just include in one of these legal tips. Don't forget also, August 1st, we do open our brand new Camden office. We're very excited to be opening at 708 Lafayette Avenue, which is just right down from the courthouse. So if you have a closing in Lexington, Columbia, or Camden, or Greenville, or Spartanburg, we'd love to help you out. Just send those contracts to neworders@blaircato.com, and we'll certainly take care of you and your clients' needs. Very excited to open that new office, and even more excited to continue working with you guys. So thanks, y'all. Have a good weekend.